on the record?
Yeah, this is on the record, and we also, can you announce the cause number since we have a new court reporter today?
Do you want me to do it, Judge?
Yeah, if you don't mind.
Yes, sir.
Are you guys expecting somebody to be calling in right now?
Are we?
Are you guys, I have a phone number, 627 is the last three digits. Is that y'all or somebody else?
To call in? No, sir. I know that Mr. Chalaki was going to join in either by Zoom or watch it on YouTube.
Yeah, Your Honor, I don't have a suit and a tie today, so I just turned off my video.
Is that you trying to
No,
message
no,
in with the
no,
627 number? Okay. All right, go ahead.
So if I may, I'm going to share. Well, Your Honor, we're here today on cause number DC 17-17249, styled Elizabeth Martinez plaintiff versus El Paisano Northwest Highway, Inc., doing business as Taqueria El Paisano, and Frank Tovar. And this is post-trial defendant El Paisano's motions for directed verdict on a number of issues.
Well, it's not post-trial, but it's, yeah, it's
post-evidentiary.
Post-evidentiary, yeah.
Yes, sir.
Your Honor, if I may, and this may save a little bit of time, and the only issue that I've seen come up for Mr. Pama so far is the future medical bills. That won't be argued from plaintiff's side, so he may not need to argue it. So we won't be submitting a future medical damage question to the court. So
I guess the proper format, Mr. Mateus, would be for me to move for directed verdict if you're not opposing it and the court granting it.
I don't know that a directed verdict per se on that specific issue makes any sense. We're agreeing that we're not going to be submitting that to the court. So there's not going to be anything for the.
Did you plead it?
Yes, sir. He pled it. That's my concern.
You need to move for a directed verdict on it.
So I move for directed verdict on future medicals. If there's no objections, I ask the court to grant it.
And it sounds like that's I'm sorry.
On future medical bills, we're not making a claim.
All right, so that is granted.
Yeah. The next issue that I'm going to move on, Your Honor, would be lost wages. Let's start with the future. I don't believe there was any evidence. Number one, there was no evidence or calculation of lost wages presented during the trial or testimony. We presented evidence that she even worked as late as March of this year. And there has been no evidence, whether by any means and method, for the court to be able to determine lost wages in the future.
Response.
Well, Your Honor, I'll chime in on that one. She did testify to that, and Mr. Payman just said that she testified to losing her job because of her memory loss. She testified to her wages. Yes, she did get employment again, but that was done. It was about a year of lost wages that she testified to.
So I guess there's two issues here. One is future lost wages, and one is lost wages in the past.
Your Honor, I'm showing the court the disclosure responses that we have. They have.
Did you just share screen? I hope you did, because I don't know what this is.
Yes, sir. Yes, sir. That's what I did.
How do you organize your files? Oh my gosh!
Wow, this is insane. I don't know what this is. The most bizarre. That's a lot of icons.
Oh. It's been crazy, but Your Honor, if I may just show you.
You're on the wrong screen, Mr. Pam, I think.
Am I on the wrong screen?
Yeah, we can see your
I'm sorry.
desktop.
I'm sorry.
Can I ask a question? Are you guys expecting anyone else to try to show up to this hearing? Because there's people showing up, and we have a 10 o'clock docket, but we have somebody who really is upset that I canceled their hearing, and I don't want to bring them into this. So are you expecting anyone else?
No, sir.
No, Your Honor.
Okay.
Your Honor, I was one of those people that got canceled, but I'm not that upset.
You got what do you mean? How were you?
Snuck his way in.
All right, go ahead, Mr. Payman.
Am I sharing the right screen now, Judge, with the numbers highlighted?
Yes.
Okay. In their discovery responses, their last one, and if I may show the court what the date is, we have, this is their first supplemental responses sent to me 20th of September last year. And if you would look down here, Judge, discovery request specifically asked for the amount and the method of calculating economic damages. They have lost in the past tense of $655,200. I don't believe there was any evidence presented in court to support the $655,200. There's no method of calculation to begin with, and I don't believe there was evidence of the dollar amount, the time that she lost from work the previous year. I mean, she works hourly, so typically what I see is somebody says, I lost 50 hours, I lost 10 weeks from work, and my rate is $20 an hour and so forth. So I asked the court on directed verdict on lost earnings.
If I may, Your Honor, again, that was done. We did have experts who did do expert reports on future medicals and on the lost earnings, but we decided not to have them testify. And that's where those disclosures came from. There was evidence we did produce to Mr. Pema, but it wasn't put into court, Miss Martinez's tax records. And as I said, we're not seeking the future lost earnings, but she did testify in court regarding just past year or 2019 lost earnings.
So Judge, I'm sorry, it appears that they're conceding directed verdict is proper on future earnings. Did I hear you correctly, Mr. Raphael? You said you're not seeking future?
Yes, we're not. I mean, with COVID-19, everything, she testified that she went back to work and for 3 months and then was laid off for COVID. So only past lost wages, Your Honor.
So can I get directed verdict on future, Your Honor?
There's a directed verdict on future lost wages.
And I also would like to still move on past lost wages because the court sitting here today, I can't figure out how much of the lost wages that she testified to were. Let me turn this off so I can see everybody's faces better. There was no evidence presented with the calculation of like, I lost 50 hours, I lost this exact number of days. So the court has to decide on its own without any evidence what the past lost wages were, because the evidence that was before you is that she worked in 2019, she was laid off, and she testified she went on Social Security benefits, and then she started working October, she said late 2019 into March 24, 2020, and then COVID hit. So I don't believe there was evidence for the court to be able to put a number on that past lost wages.
I believe that there is evidence, and that's all we need, is that there's some evidence there. We have the specific dates that she was unemployed. She testified to how much she was making. Obviously, Mr. Raphael can make that easier for the court in closing in terms of what that calculation would be, but it's ultimately, there has been evidence provided for which the judge could award lost wages. So there's some evidence.
There was a case that you guys cited yesterday out of the Supreme Court about what happens if you don't do a calculation, and I wasn't sure if that was relevant to this or not.
I never got that case cite from Mr. Pema, so.
Judge, that is not on this one, but there is case law that says that the evidence, and in fact, I argued that in Judge Tiller's court before COVID, on my last trial before COVID, that the court cannot decide unless there's evidence before it. It was a breach of contract case as to the damages. There has to be, hey, I lost 80 hours of work and I get paid $20 an hour. So the court can do a multiplication and say, here's your lost wages. The court cannot just arbitrarily say, okay, you didn't work 6 to 7 months. That's not how it works. There's got to be evidence to say, I lost this many hours. This was my rate of pay. So without that, and I'll be more than happy to send the court that case law, and I'll send it to Mr. Raphael. And you can make that decision, I guess, on Tuesday if need be. But I don't think there's any evidence that I lost $32,587 in lost wages. I don't think I ever heard that, and I don't think the court heard that. So I don't believe they met their burden of establishing the dollar amount of the lost wages. And if you look at the method of calculation, it is true that they did send me their experts report that talked about future, but no mention of past with a dollar amount saying she lost this much from work, because I think that was done about a year ago while she had just lost her previous job. So I believe I'm entitled to directed verdict on past lost wages as well, because I don't think the court can say, yes, she lost $32,387.52, and I may be granting that.
I believe there's enough before the court with regards, we have a specific
What is the calculation? I guess I remember her talking about she missed time. I don't remember. Did she testify about how much she made an hour?
Yes, she did. She testified she made $17.50 an hour and about 37.
That's right. She did testify to that. You're right. And then did she say how many hours a week she worked?
Yeah, she said to the court she made over about 37,000 a year, Your Honor, at full time, and then had to get the job in March or in end of the year where she was only making 16 an hour. So it changed. So she didn't work from March till October.
Your Honor,
Did you give an exact number? Oh,
No.
Go ahead.
Your Honor, I don't understand how that adds up to 655,000.
We're not seeking.
Nobody's alleging that.
Yeah, we're not seeking that. That expert report talked about past and future. We're not seeking future lost wages of 650,000. We're only seeking for the lost wages, and this is one line of that time in 2019.
And I think the judge's question was there a number of hours that she lost? Am I correct, Judge, before Mr. Chair?
I'm just trying to figure out, like, how do you do the calculation? So she missed from August to, what did you say, December?
Yes, Your Honor. No, she missed from March, was let go in March because of her memory loss, and then got the new job.
Oh, she worked from August to March, and you're arguing that from March to December she didn't work. Is that it?
Correct, Your Honor. And I'll pull up the testimony, but yes, it was something around those lines. And she testified how much she made a year. So it's just a simple calculation, frankly.
Well, it's not, Judge. I mean, I'll give you case law that the calculation should not be led up to the court. The calculation has to be presented that I missed 10 weeks, 20 weeks, 30 weeks, and this is how much I was making. I agree she testified how much she was making. I agree she testified that she got a job and she was let go on, I think she said March 24th when I asked about COVID. And so the issue is, it's their burden to give the court evidence of the calculation of the past lost wages. They have not given it to me on the past. Mr. Raphael, I was up till 2 o'clock, and believe me, I did review the expert report, and it speaks about future. It does not speak about the past. So there is no calculation of past wages, which is required under law. And I don't think if the court has notes of how many weeks she missed, then I'm wrong. But I don't believe that is. And the fact that you have to ask that question, Judge, where is the evidence, tells you that it was not presented the way that the law requires it to be presented to the court.
There has been evidence presented to the court specific that would allow the court to be able to make a calculation. We have rate and we have time. Those are the two things that are needed, and those things are in evidence and have been testified to. The fact that she didn't testify to a specific number, the court has everything it needs to come up with a calculation based specifically on the evidence. If she hadn't testified about when she stopped working, when she started working, okay. If she hadn't testified with regards to how much she made, okay. But you have everything you need to make that calculation. That's what the courts are requesting. The fact that you press the equal sign on the calculator is not the issue.
Your Honor, let me address that the way that Mr. Mateus is presenting it. She testified that she left her job in March 24th of this year. She never testified that she's currently unemployed. She never testified she did not get another job. She said, I left that work on March 24th. So I watched the YouTube, believe me. It's 3 days of trial, and I watched the YouTube, and she did testify that she lost the job on March 24th. She never said that she's still unemployed.
She said that she went back to work in December, right?
I think she said October. She said late, and she said October. And I said October, November. She said, yeah, roughly around there. And I said, when did you quit? She said March 24th. And I have that clip, not here, but I got the clip ready for my closing arguments. But so how do you calculate when she went to work and when she left? And she never testified that she's not employed now. I beg the court to. I can present the video during my closing because I have it tagged and everything. If I can.
Oh, that's kind of interesting. I guess you could do that in closings. You could do video from the YouTube.
instead of reading
Oh,
transcripts.
that's interesting. I haven't had anyone do that. That's really a cool idea.
Judge, I have my daughter. I have my daughter at home watching, and she actually does mark the numbers and locations where I ask a smart question. They're not that many marks because I ask, but only smart questions, so it's rather easy for her. But I do have all the clips, and
How
the
interesting.
court can reserve that until we present it. But I don't think the court, because I saw you taking notes, and I don't believe there was evidence. I mean, she did say I didn't work, but she never said she's not working now.
But
We
No,
again,
I think
that's not
they're
the-
just
not working now,
asking for
it's
March to October or March to December. I don't remember the exact testimony. I'm sure you can show it, or the other side can show it, but I think there's enough there to make a calculation. You can argue over the exact amount, but there's definitely enough there to make a calculation. So I'm not going to grant a directed verdict at this point. We'll have to see. I would urge you guys maybe to, cut the video or make sure that you have the exact testimony on that point. But anyway.
Okay. That's about it, Judge. So just to make sure I understand you correctly, you have granted directed verdict on future meds, and you have granted directed verdict on future lost wages. No, past lost wages. Which one is it?
Future.
You
lost
granted on
wages.
future. Okay.
Future lost wages and future medical bills.
Okay. So those.
I may not consider. We'll have to see what exactly the argument and the calculation is for past. I think that there's enough there at least to get to the jury, so to speak. Have you guys taken a look at the whole issue about do we need to do comparative on the? Have you guys talked about the charge at all?
Your Honor, I had a thought last night, which I think makes sense in a little more simple for thinking of this, let's say, as a jury trial.
Mm-hmm.
Ultimately, plaintiff can go forward with multiple causes of action, doesn't have to prevail on each one of those causes of action. So in essence, it creates a situation where there's an election. So we have our negligence question, then we have our assault question and false imprisonment question. If plaintiff succeeds, let's just say, for example, on, let's say 95.5, okay, to complicate things in the negligence section. And then the court goes forward to the assault question and checks yes. In essence, the plaintiff has an election there in terms of prevailing of whether to go forward on the assault or whether to go forward on the negligence. The damages shouldn't be separated, but in terms of what cause of action you're going forward on, that's where it ultimately plays. So in essence, there is an election there based on the different causes of action that are going forward, but I think the damage model stays the same.
Your Honor, I disagree. I kind of understand what he's saying, but I disagree with something he may have said or omitted. I've had a number of cases where you get to elect. So for example, you sue somebody on breach of contract and you sue them under DTPA. There are awards on each one, and then the plaintiff, the prevailing party, says, you know what, I want to collect on my DTPA because I got treble damages, or I want to collect under my breach of contract because I get interest. So the election comes after they see what it is. So for example, if the court awards $10 for assault, but awards $50 for negligence, that's when they say, you know what, we elect the negligence claim, and we don't want to do this one. You don't do it because right now you're combining damages for different cause of action under one theory, which you cannot do that. And I'd be more than happy to I had to present this case in Fort Worth on a breach of contract, fraud, and a DTPA. So different awards were given for different cause of action, and then the plaintiff, the prevailing party, elected which one they want, and that was placed in the judgment. I don't think you can combine the damages. That would be reversible error. It's for your benefit.
Can Mr. Pema explain what damages are different between assault and negligence?
Well, the hypothetical is the judge has to find a percentage on the assault. The judge has to find a percentage on, stay with me. And the judge will have to find percentages on the negligence. So hypothetically, if the judge finds 60-40 in your favor on assault, but finds 80-20 on negligence, you don't get to collect 80-20 on the assault regardless of the dollar amount. Believe me, that's the case law. And I'm doing this so you don't have to waste 2 years in appellate court.
I understand. Do you have a defense of comparative fault in assault?
Well, yes, it was act of a third party. I mean, it wasn't until yesterday that the judge made a ruling finding that we had control, but control doesn't mean employee. Judge said that we had control, and I wrote it down, right of control. That's what the court said and suggested to us not to waste our time too much on that. So there is case law that differentiates between assault and negligence, because you have multiple allegations of negligence. So the judge, for example, could find under negligent hiring, because and that the damages and that could be different. I don't see what the problem is with the court saying, I find assault at this percent and this is what I award. I find negligence this amount, this percentage is what I award. And then you get to pick the highest one. It's to your benefit, not my benefit.
But the issue, I think, is so we have 3 causes of action or 4 causes of action?
Three.
We have negligence, no, we have intentional infliction too, don't we?
Yes, that's the third one.
No, 4. I think
and assault,
false imprisonment, negligence, intentional infliction.
So to each of those different causes of action, there are different defenses. And I'm just looking at the causes of action. For example, false imprisonment, the defenses are limitations, immunity, plaintiff's fault. So you can do proportionate responsibility on false imprisonment. I didn't know that. Okay, yes, so interesting. Okay. I wonder if all of them have that. Let's see, battery or assault.
Judge, let me know when you're in the intentional infliction, so we can point something out to the court.
Yeah.
Because I think that one should also be taken out. And I'll explain to the court in a second, if we're looking at the same book.
Okay, let's go to intentional infliction, I guess.
Do you have the new book, Judge?
I do.
Do you know what page it's on? Because they've changed. Well, I found it. It's on 427.
Oh, wait, I don't know. Maybe I don't. I have the 2020 version. Is there a 2021?
Yeah, that's the one I have.
Okay. So I have that's an invasion of privacy. Oops. So at least as the false imprisonment, comparative is a defense.
Yes, sir.
427, yeah, you're right. So why do you think intentional infliction isn't a...
Your Honor, if you're looking at the same... yeah, we're looking at the same book. Is this the book you're looking at, Judge?
Yes.
Okay. If you look at page 428, it lists the elements of IIED. I like how they abbreviate everything. And if you look at number 6, it says one of the elements is that there is no alternative cause of action would provide remedy for severe emotional distress. Under negligence, they're entitled to pain and suffering, mental anguish. As such, you cannot have both, because there is a cause of action that could remedy that mental anguish. So that's why intentional infliction doesn't apply, because they've pled other causes of action that could give them the remedy. So we're just muddying the water, and this is clear out of this authority cited all the way down here. Since they've alleged false imprisonment, since they've alleged negligence, since they allege assault, all of those allow them to get the remedy that could be provided under intentional infliction. As such, they don't meet the elements. So that needs to be taken out, because if the court's going to award mental anguish, which is
let's see what it says about that. I've never heard that argument. I'm not saying you're wrong, but let's see. No alternative. Okay.
What page are you on, sir?
I'm on page 434.
Is there a case site for that proposition?
Oh, yeah, there's a ton.
Supreme Court cases, yes.
Yeah, there's quite a few. Credit Watch Inc. versus Jackson, 157 Southwest 3rd, 814, which is a 2005. Hoffman dash LaRoche. Hoffman is with two N's dash LaRoche, LA space capital ROCHE Inc. versus Zeltwanger, ZELTWANGER, 144 Southwest 3rd, 438. It's a 2004 Texas Supreme Court case. A Standard Fruit and Vegetable Company versus Johnson, 985 Southwest 2nd, 62. Vaughn versus Drennan, 372 Southwest 3rd, 727. Drennan is DRENNON. Draker versus Schreiber, SCHREIBER. Martinez versus, I mean, there's a lot.
And Your Honor, if you would look at on that same section, if you go like 1, 2, 3, 4, 5 pages, 5 lines up, where it cites the Hoffman case, and if you go right above that, the sentence that ends after 144 Southwest 3D at 447, it says, if defendant's conduct would support an alternative cause of action, the plaintiff is barred from pursuing on the alternative claim. I just don't want to muddy the water with 50 different causes of action when it's
I mean, I'm inclined to grant a directed verdict on that because you definitely have a argument for false imprisonment, negligent hiring, negligent supervision, battery. I don't think that intentional infliction is really necessary. It's a gap filler where there's not some other way to pursue it. What do y'all think?
I think that's what the Supreme Court says.
I'm inclined to not have an issue with it. I would appreciate, some time to research it. My only thought offhand would be it being pled in the alternative. And if the court does grant on negligence or assault, it's rendered moot.
But I think it says that it's barred from being pled if you've pled other ones. So you're barred from pleading it if you've pled other cause of action.
Does it say that? I don't know.
Yes, sir. That's what I just read to you, sir.
Your Honor, it's kind of like the premises liability cases where you can't claim negligence and premises liability on the same exact defendant.
Judge, it says if defendant's conduct would support an alternative cause of action, the plaintiff is barred from pursuing an IED claim. Barred from pursuing it.
Okay. Yeah, I just, you can move to reconsider, I guess, on Tuesday when we do closing, but I'm going to go ahead and grant the directed verdict. I just don't think it's applicable in this particular set of facts. So we're down to assault, false imprisonment, and negligence. And it looks like false imprisonment does have comparative as a defense. So it makes sense to kind of have it before the, you'd have the negligence question, then you would have the false imprisonment, I'm trying to think, is there any damages that would not be associated? Because false imprisonment has the same elements of damage that negligence does. So I don't know that there needs to be two different questions on damages. At least that's my initial thought.
Well, you're right, but you could find, for example, no false imprisonment and only damage and only negligence, or vice versa. You may find no negligence, but you may find false imprisonment. So just putting another paragraph, I don't think it's going to really harm us, but it allows the court to, after reviewing all the evidence, say, you know what, I find negligence, but I find no. So combining them could be misleading because we don't know what even though the damages are the same, you're right. But I think that would be also misleading on that aspect.
Are you proposing that we have two damage sections?
Yeah. Just like you do in the breach of contract and fraud, just like you do breach of contract and DTPA, you have two different damage models because they could be different.
But we don't have different damage models.
I understand.
That's ultimately, the contributor is ultimately applied. So, for instance, think about it in a verdict. The jury's not applying that percentage.
All right. So let me ask you a question. This is where you got to be careful. Let's say you combine the two. Mm-hmm. Even though the elements are different, let's say the judge finds, and you just submit it as a negligence claim, and judge finds no negligence, but wants to find false imprisonment. So the judge has no way of saying, I find you guilty of false imprisonment and I'm going to award you damages, because that's if it's a negligence question. It works in my favor because it eliminates one of the cause of action. But I'm just trying to avoid. I don't know what the harm is if the judge is going to award the damages. This is not a jury situation where we're going to confuse the jury. This is a bench trial where the judge knows the law better than both of us. Having 3 different sections for the judge to fill, I don't think it's going to be that big of a deal, because there could be different percentages assigned on negligence and on false imprisonment. There could be.
Mhm.
So if the judge assigns 60-40 and the other one 70-30, how do we figure out that percentage? Just having that extra block, I don't think is harmful, so that we understand what was awarded. I don't know what the problem is with having just 2 blocks. Well, we have to do the work, just has to just fill out the numbers. I mean, think about it. What if the judge finds 60-40 on negligence, but 70-30 on false imprisonment? How do we do the percentages on those?
So then the plaintiff ultimately has to elect one of those, can't proceed on both.
Correct. And the
Right.
numbers would be different.
The numbers will be different. So the court, just like with a jury verdict, if
Right.
we're submitting a judgment, there's a 95-5, the jury's not applying the 95-5.
Correct.
Ultimately, we have to submit a judgment where the
Right.
95-5 is applied.
That's the one that you pick.
So unless there's different damages, like with
Different percentages. I mean, the example I gave you, judge may find 60-40 on negligence and
Correct.
70-30 on false imprisonment, and awards $1,000 on each one hypothetically. So do you pick the $600 or do you pick the $700? Because it's not presented properly, we can't make that determination. That's all I'm saying. You're going to create problem. Believe me, you're going
I'm
to
just
create.
not, let's see. So I'm looking at also at assault. It also allows for comparative. This is kind of interesting because you're right, it usually doesn't get to this point because there's insurance and people don't want to try to allege this stuff. So you have 3 different causes of action. All of them can do a percentage. I guess my question is, how is it best to submit, to do this? I'm inclined to disagree with Mr. Payma on this point that there should be percentages as to, there shouldn't be a different percentage to each one, but there are different defenses to each different cause of action, but the percentages probably should all be the same, is my inclination, because I've had an issue once like this before where there was more than one cause of action, we just did one percentage, but I don't know for sure. You might want to talk to appellate counsel on how you want to submit that. But one other thing to think about for false imprisonment and assault, there are a lot of different defenses, but I don't know what's been pled because there's
Your Honor,
justification and immunity and all sorts of other stuff, self-defense.
Your Honor,
Has any of that even been pled?
what's make it difficult? What has made it difficult for us is that you ruled on you. I shouldn't say you ruled. You made it known to us that you are going to find that El Paisano had the right of control at the end of the evidence. So up until the trial time, we were relying on independent contractor security guard. Now, you found after the evidence that
doesn't excuse you from pleading defenses, though.
But Judge, I cannot assert a self-defense because I don't represent Mr. Tovar. So there's no allegation that any of my employees assaulted Ms. Martinez. So I had no self-defense because there was no allegation of assault.
Let me just ask this, was assault and false imprisonment alleged against El Paisano or just against Tovar?
The way that you read it, they say that Tovar took her outside and assaulted her and put her in handcuffs. And that's
but I'm asking a much more mechanical question, which is what was pled? Did they plead assault and false imprisonment? Can you bring that up, Mr. Raphael or Mr. Matthias?
Sure, I'll have Mr. Raphael bring it up just while I have it. what's been argued here from the beginning in terms of the question of whether or not employee or independent contractor has been there from the beginning, the allegation of vicarious liability through El Paisano. They may not agree with it, but the law is clear with regards to vicarious liability for intentional torts that are within the course and scope of employment. So it's foreseeable that there could be a finding of assault that will flow through to the employer. So I think it was imperative upon them, due to the vicarious liability, that they assert that defense, which could have been placed on them.
And I have it here, Your Honor. Let me pull it up. As you see, we do say defendants, and they've had the opportunity to argue that they're agents, employees, managers, independent contractors.
Okay, so it's against all defendants. What about false imprisonment?
And that's the argument we've been making from the beginning, that they are all one and the same.
Your Honor, if you look at paragraph 33 and you come down, if Mr. Rafael would come down, this is what they're claiming. Grabbing plaintiff while in the restaurant, that's Tobor. Hitting plaintiff, that's Tobor. Slamming plaintiff to the ground, that's Tobor. Pepper spraying plaintiff, that's Tobor. And if there's E and F, I don't know if there's E and F on the next page, Mr.
But they're arguing that Tovar was your agent.
Correct. I agree with that.
I mean, okay. So you would have to. So I guess let me just see on false imprisonment.
I believe it probably will be the same then.
Defendants, they're agents, employees.
Yeah. Okay. Yeah. So let me now look at the most recent answer of the defendant.
It would be our third amended, Judge, and I can pull it up for you. My system's running a little slow. We have to put up so many security things for this COVID and stuff that's
While he's pulling that up, PRC 41005 says that the act of the individual, which is Tovar, has to be assault. And that independent act had to be guided by, for example, El Paisano in order for them to be held liable. So if you find it for Tovar that has committed assault, then it goes up, and then they had to knowingly and tell them that, hey, go commit that assault. In order for El Paisano to become part of it.
We'll argue. We'll argue with that. We'll argue with that at closing, Judge. I don't know.
Well, let's. What was pled? That's my question. What was pled?
Yeah.
And I'm just trying to find. I'm almost there. It's Friday. My computer doesn't. I believe this is the one, Judge, and I should have pulled it up from the court's records instead of my own. Yes, sir. May I share my screen?
Yeah.
And I want to make sure I share the right one. Okay. This is our third that was filed on March the 10th. Okay. And we have pled, we show the same time and occasion question plaintiff was guilty of one or more negligent act commission, which were the sole proximate cause and proximately contribute to the cause.
So you have sole proximate cause.
Or proximately contributed.
Okay.
Defendant further disciplinary injury, if any, caused by the acts of a third party who was not an employee of this defendant. Defendant requested jury instruction in the charge.
Right. Okay.
The status defendant is not vicariously liable for Frank Carlos as he was an independent contract, as that term's defined. This is when we did the security guard company with respect to hiring and training.
Okay.
Defense denies that any of his employees intentionally, knowingly, or recklessly caused bodily injury to plaintiff, or intentionally, knowing, recklessly threatened plaintiff with imminent bodily injury, harm, or intentional. I'll let you read it.
Right. Okay, keep going.
And then we asserted the other ones. So these are the ones, Judge.
So you did. So my question was there's specific defenses to false imprisonment and specific defenses to assault that were not pled? Because, for example, I'm looking at assault. There's justification. There's self-defense. There's let me see. Defense of a third person, protection of plaintiff's defendant's property.
We did plead the third. We did plead this one,
Yeah, but you didn't plead defense of a third party.
No, sir.
So like you weren't saying that he was trying to protect the cashier, for example,
No.
that they were employees of a correctional facility. There's all sorts of
Correct.
provocation.
Correct. But we did plead that he was not an employee. We did plead that.
Right.
Yeah. We did.
I'm not saying you can't plead those. I'm just saying there's certain defenses that are available for different causes of action.
Correct.
Those defenses were not pled.
Correct. But again, all I can say is that because even though they asserted that he was they asserted he was agent, employee, or independent contractor. I don't think there's a dispute that he was an independent contractor. I think the court found that we controlled him. There's a difference between those two. So we represented our side saying that we didn't do anything to her. And if anything happened to her, it was done by Mr. Tovar, who was involved in the physical contact. Had I started alleging defenses for Mr. Tovar, I would be representing Mr. Tovar because none of those apply to me.
I disagree with you because they're arguing that they're trying to argue that your agent did these things, so you may have disagreed. You could have pled in the alternative and said, "Hey, look, we disagree. He's our agent, but if he is our agent, these are the defenses," and those weren't pled.
I agree with the court.
I mean, so I'm just trying to figure out how this is gonna look on the day when we do closings on next Tuesday. All right, what else do we need? So when we're filling out the kind of judge's form, as we can call it, there's not going to be any specific defenses or any of the defenses, the unpled defenses, I guess, to assault or to false imprisonment. I think the assault and false imprisonment claims should come before the percentages claims. I think they all have the same damages, so we can include those. Let's talk about gross negligence.
I was going to move on that one as well. There was no evidence of gross negligence, Your Honor.
Go ahead.
Your Honor, you heard the testimony. There was evidence that Mr. Tovar took him out. Now, depending on who the court believes, regardless of what the court believes, element of gross negligence is that we had to know the action foreseeable that this will happen. And I don't think they showed no malice. I asked them if they knew each other, there was any animosity. There was no evidence of malice. There was no evidence of foreseeability on our part that arresting her would do this. We did pepper spray her. I shouldn't say we, I'm just saying we because of what you said. She was pepper sprayed, but I don't think that meets the level of gross negligence. Just the elements of gross negligence were never even presented to the court.
Response.
Corey.
Yes, Your Honor. Well, if you look at our pleading, and I can share it now, our pleading is very clear. We're talking about specific flagrant disregard of the law, especially the Texas Private Security Act, intentionally employing unlicensed guards, controlling that manner of the flagrant disregard. And I can share my screen of how we pled that. That the amount of force, of course, was just beyond anything reasonable. And the actions were malice because Tovar was in their control. The fact that he body slammed her, pepper sprayed her 6 inches from her face, UFC armbarred her. And again, defendants have not presented any evidence whatsoever other than Tovar's testimony. As also we saw in Tovar's testimony, there were other witnesses that were never brought forward by defendants. There was a report, there was evidence to discuss the matter, photos, that nothing was produced by defendants. And they've had plenty of opportunity to. They should not be able to get away with that, especially given our pleadings and the evidence we presented.
Your Honor, again, everything he said does not constitute gross negligence. It may support another cause of action, negligent hiring, for example, but it does not support gross negligence. Gross negligence is very specific, Judge.
I don't know what he's going to refer to some case and say he's seen a case, but specifically here, they had a direct violation of the law, knowingly violating it and these are strict liability laws. You are fined no matter what if you violate these laws regarding the Security Act. And also, I mean, let's put it this will be part of my closing argument, Your Honor, and that's why we need this in here. Again, defendants have shown no evidence. We have shown clear evidence that El Paisano knew about this. They knew about Tovar. They knew about him being unlicensed and Obregon. They had contracts, they had evidence. And frankly, we pled spoliation, which was shown during trial based on their only witness. Again, they presented no evidence otherwise. We presented above and beyond that the cashier told him to take her out. He took her out. It's very clear. And then they kept him on for a year and a half afterwards, Your Honor.
Again, that does not.
No one intervened as well in terms of this whole foreseeability argument from the time that she's taken on. There's no evidence at all. Both Cano and Tovar testified that the employees of El Paisano and the manager could have come in and broke up what was happening, and at no point did anybody at El Paisano come in and intervene.
Your Honor, I don't want to argue the case again, but I do have to respond.
I think there's enough. I'm going to deny the directed verdict on this. I think there's enough to go to the fact finder on this. So can you pull up the most recent charge that you submitted on this case so that we can kind of talk about how it should be submitted?
Yes, Your Honor. You're talking about the jury charge that we submitted in February?
Yeah.
Right.
Do you want me to go through each one, or where would you like me to?
Just start with the questions. You don't need to give me instructions on how to answer.
Don't go on MySpace.
Yeah.
You gotta be careful, right?
Hey, I usually ask juries that if they've been on MySpace, and it's funny. I guess it still kind of exists. There's about one of every 3 juries somebody's been on MySpace. All right, so question number 1 is fine, I think. Let's keep going down.
And so what about the instructions that we have in there regarding the security company and occupations code?
Yeah, I think that's fine. So have you looked at the issue of combining Tovar and El Paisano?
I mean, I thought from what you told us yesterday, Honor, just to put them all in one, together in one line.
That was my inclination, but I also said that I've had reversible error on that issue with the nurse. Remember, I talked about that with you all yesterday.
Yeah, and I believe Mr. Payne was supposed to send us something on that. I waited till 3 a.m. for his email, but.
No. That was, I believe, on the other issues that you said we're going to discuss on Tuesday. But I'll be more than happy to. In fact, what I was going to do was file a brief with the court on those issues on Monday, and I will send it to Mr. Raphael. Same time I follow with the court, so he will have 24 hours to know. Now that you still,
it's not a huge deal because again, since you don't have a jury, this is just going to be how I announce it. I'm going to announce.
Judge,
what is your position, Michael, specifically, I assume that's what you're talking about on the jury line.
Judge, may I put my jury charge up there, see if this is what you're talking about?
Sure.
Because I think, again, I've been wrong before many times. What I have, the way that I prepared mine was like this. And I did. It starts with, I'm sorry. This one starts with, was he an employee? And we can change that to I'm just saying that's how I had it back in February. And then the next one, did El Paisano commit an assault against Elizabeth Martinez? And the next question was, did Frank Carlos Tovar commit? And then intentionally, I guess this one's out. We don't need to deal with it.
Yeah, I don't like this setup at all.
Now I'm hurt, Judge. You love his, but you don't like mine. And then here's where I put the percentages on the negligence. And then I'm sorry. So this is the way that I did. This is typically I do.
You
it.
do need to include the predicates. So this is where if this is an actual charge, this is a point where I think okay, can you pull that? I'm sorry, you pull up that last.
Oh, put it back up.
Yeah, put it back up where it talks about the predicates.
Which one?
Right where you were. You keep moving it. Okay,
Here.
right there. So all three of these remaining causes of action have comparative fault as a defense. And so so there needs to be a predicate before the damages question on something like this. And it should say answer question number, whatever. Let's say the damages question is question number 6. Answer question number 6 if you answered yes for, I guess, defendants, to question number, whatever the liability question. There's going to be a different liability question as to each of the different 3 causes of action. Right. And no for Elizabeth Martinez to any of those liability questions, I guess. And then 50% or less for Elizabeth Martinez to question number, whatever the percentages question is.
Yes, sir.
Does that make sense? So there needs to be a predicate in there.
Yes, sir.
Your Honor, just to clarify, I mean, in going through Mr. Pama's pleading, there's only an affirmative defense of contributory negligence. Doesn't go to the other causes.
I thought it pled comparative fault. Is that not correct?
No, it said that Ms. Martinez was negligent in contributing.
Yeah. Well, that's comparative. I said she caused her injuries.
It's specifically negligence.
Let me.
I think, it's a notice pleading state. I think that's enough to get comparative as to all 3 causes of action. But you want to brief that, you can, but I think that's enough. I guess just conceptually what I would say, there should be 3 different causes of action. One for assault, one for
False imprisonment,
one for negligence. There should be a percentages question, and there should be a damages question. And then there should be the gross negligent questions. That's kind of conceptually how I'm thinking about it.
yes, sir.
Okay, so what else do we need to kind of chat about?
I believe that's about it. So I guess I can always pull up the YouTube video and figure out which ones are out and which ones are in.
Your Honor, would it be helpful? Do you still want us to do the kind of color coded for council to get together and then submit?
I still think, yeah, I do think it would be helpful. Hopefully it will be agreed to at this point. I don't want you to, there's no need to, this is an interesting question. There's no real need to preserve air, so to speak. I wouldn't think. And so this is interesting. I'm trying to compare this to a jury trial, but it's not exactly the same. So, but I do think the red line, blue line charge would be helpful. And again, just for the questions, to know if there's anything that you don't agree to as to the form of what the charge or what I should answer should be.
Mm-hmm.
You know what I mean?
Yeah.
It's not a preservation of air, but you may not have to do something quite that formal for a non-jury, but something that kind of
gives you an idea of where our position,
what our positions are, so that I know, because I would really like to go pretty much directly into the closings once we start up again on Tuesday.
Sure.
Mr. Paymer, you're muted.
Just for the thank you. Just for the benefit of Mr. Mateus and Mr. Rafael, I am open all day Monday. So if they want to check their calendar, maybe we can do a Zoom and look at documents and I mean, unless they want to come to my office or I come to their office, if they want to, I'm open to that. But if they rather do it by Zoom, I'm open to that as well. So we can talk about that afterwards and schedule it, and we can do what the court's asking us to do on Monday. That gives us the weekend to prepare whatever we need, share, compare, and see if we can agree on them. Keep that offer. I mean, I don't need an answer right now, Mr. Rafael or Mr. Matthias. But
No. I'm sorry.
Keep that
Yes, that sounds good.
So
Yeah,
we
we
don't-
can talk- there's COVID, so we don't have to see each other in person.
that's fine.
Yeah, no, you don't need to, I instruct you not to see each other in person.
I mean, I just wanted to make the offer open, but we can do it by Zoom. That's fine, and we'll do it.
Perfect.
So let's plan on talking afterwards and setting up a time, maybe by email. Let me know what your availability is.
Got it.
Judge, are we excused? Are we done? Anything else the court wants to tell us?
I think that's probably it. So let's go ahead and reconvene on Tuesday. Anything else you guys need to chat about?
I don't think so at this time.
Mr. Pema, did you get the past medical damage model as well?
The past medical damage, we have that. Yes, we have that.
Okay, I will